Okay, I think we could go ahead and start. So hello, I'm Mary Kay Rizzolo from the Council on Quality and Leadership, CQL, and I want to thank you for joining us today for a webinar from Equip for Equality on guardianship and rights of individuals receiving HCBS. So I'm going to cover just a few housekeeping items before we get started today. All attendees are muted and in listen-only mode. You'll not be able to speak live during the webinar. Please note that the chat box is turned off for attendees during the webinar, but you can submit any questions, comments, or technical issues you may have through the Q&A box located on the Zoom control window. We will devote some time at the end of the webinar to answering as many questions as we can. And this webinar is using Zoom's built-in live transcription, closed captioning service. And to turn that on, you can click on the live transcription button on your Zoom control window or show captions. And finally, this webinar is being recorded. In about a week, we'll be emailing out a link to all registrants where they can access the webinar recording. So that is all. So I'm going to turn things over to our presenters, Stacy Ashman, Vice President of the Independent Monitoring Unit at Equip for Equality, and Christina Hadley, Senior Attorney and Illinois ADA Project Manager in the Civil Rights Team of Equip for Equality. Thanks.
All right, well, hello everybody. I'm Stacy Ashman from Equip for Equality, and thank you, Mary Kay, for getting us started. First, I want to thank everyone for coming. It's so exciting to have so many people here to hear about and talk about this important topic. And I'd also like to thank the Illinois Council on Developmental Disabilities, as well as CQL, for involving us in this important project. So first we have, let's see here. All right, so in terms of the things we'll be covering today, first, I'm just going to do a brief overview on capacity and decision-making. Then we'll briefly speak about some alternatives to guardianship. We'll talk about guardianship in Illinois, including the standard for guardianship, the types of guardianship that are present in Illinois, as well as a ward or the individual with the disabilities rights and a guardian's responsibilities. Then we'll move on to the provider's responsibilities under Illinois law and home and community-based services settings rules in the context of guardianship, as well as discussing some scenarios that I hope people will feel open to sharing some of their thoughts about. Right. So first, on the topic of capacity and decision-making, we'll look at issues surrounding guardianship as well as alternatives. Who has the, I'm sorry, I've moved on from that. In terms of the, who has authority to make individual decisions, you're looking at someone's capacity and determining when that is appropriate to have someone else that's making decisions for an individual. So capacity is not a question of whether someone has the ability to make good decisions, because it's really difficult to measure what's a good decision. A good decision for one person might not be a good decision for another person. And we can think about with capacity what a poor decision looks like. And so instead of being a bad decision, a poor decision, we're looking at, does the decision only look at immediate benefits, not consider, consequences? Does it oversimplify issues? Is it influenced by emotion, or is it otherwise reactive to a situation instead of someone taking their time? So when we're also looking at capacity, we're thinking about whether someone can follow the decision-making process. Do they understand the situation? Are they gathering information upon which to base their decision? Are they considering different options and consequences? And are they ability to communicate what their decision is or implement their decision? Someone's ability to make decisions or their capacity also can be a continuum. So they might be able to make some decisions, but need help with making others. Now, in terms of some different alternatives to guardianship, people sometimes will confuse guardianship versus powers of attorneys versus a parent. Oftentimes we'll hear someone, if we ask if they have a guardian, say, well, my mom. But then it turns out they really aren't a guardian, they're the person's parent. So these things are all very different, of course. With regard to guardianship itself, it is established after a full court hearing and process. So first it starts with an individual organization filing a petition in court, and they have to be appointed to serve in that role. That appointment would not happen unless there was a full due process rights afforded to the individual with a disability, which includes the right to be heard, to present witnesses, to cross-examine the other side's witnesses, and to present exhibits and things of that nature. If after going through the whole process, the court deems the guardianship necessary, the court will enter an order appointing a guardian, as well as letters of office. And those letters of office are really important because they define what the authority of the guardian is. If someone is not able to present an order or letters of office, there is no guardianship. So for instance, just because an individual or provider starts the guardianship process, until an order is entered and letters are issued, there is no guardian in place, and the individual has decision-making rights until such time as an order is entered. Now, guardianship is a very intrusive situation to be in. It should only be put in place if it's truly necessary. So it's important to consider whether alternatives can be put in place to meet the individual's needs, to avoid this type of basically taking away someone's legal authority to make decisions for themselves. So one of those alternatives can be a power of attorney. This is also a substitute decision maker, but it is someone that the individual chooses for themselves in a written document that designates the agent who's making the decisions, the limits of their authority, so what they can make decisions about, as well as when they can start exercising their decision-making authority. When someone signs a power of attorney, they have to have the capacity to sign that. And that basically, they have the basic understanding of who they are giving authority to and what they are giving them authority to do. So they just have to understand that in order to sign it. So if someone is completely without capacity, they should not be signing a power of attorney. If they're basically just putting their name on the line, but don't understand what they're signing. In terms of a power of attorney for healthcare, they are generally giving someone authority to help them make healthcare decisions, as well as access their medical records. And an individual under a power of attorney, or an individual giving someone a power of attorney for healthcare, can revoke it even after they've lost capacity. This is in contrast to a power of attorney for property, where they cannot revoke a power of attorney for property if they've lost capacity. So if an individual is no longer able to communicate, make decisions, they cannot revoke a power of attorney for property, but they can for healthcare. Just one little distinction to be aware of. And also for a power of attorney of property, of course, that involves giving somebody the ability to help you make decisions about your property, whether that's money or other kinds of property, such as real estate, and also access your financial records. And then another alternative to guardianship, say the individual just needs assistance with managing their Social Security benefits. That would be a representative payee for Social Security. In these cases, Social Security will appoint someone who is unable to manage their funds with a representative payee, and Social Security maintains some monitoring of the representative payee. And Equip for Equality actually has a contract with Social Security as well, and has some involvement in overseeing representative payees. The representative payee must ensure that the individual's money is first used to buy food, clothing, and shelter, and then kind of take care of any other expenses the individual has. Of course, that the representative payee is a fiduciary, just as power of attorneys are, and cannot use money for the individual's money for themselves. And then another alternative to guardianship that I wanted to share with you was a more recent Illinois law that came into effect, putting in place supported decision-making for people with intellectual disabilities as a means to not seek out guardianship. This law became effective in February of 2022, and it's different from guardianship and power of attorney and representative payees because in those cases, someone else makes the final decision, but in this supported decision-making, the individual retains final decision-making authority with the help of their supported decision maker. The supporter can be a friend, a family member, a coworker, a colleague, or someone else with professional skills. The main point is that the individual chooses who their supporter or supporters are to help them make decisions on the specific areas that they're seeking assistance with. Now, there has been some research on this before, and the evidence shows that this really is a good way to help people, both in terms of improving their health. It encourages individuals to try new things, to test their limits, to discover their capabilities, to learn from their mistakes, just like everybody else does. A lot of people all over use other individuals to help them make decisions about topics where those individuals maybe have a little bit of knowledge to share and help them come up with the best outcome for themselves. In terms of the outcomes for individuals, when they have a support decision maker, it causes the individual to be more actively involved in their lives. It has better mental health outcomes, can promote a better quality of life, and also help the person become more independent. The Illinois Guardianship and Advocacy Commission does have some sample forms and materials on their website that includes some sample supported decision-making agreements. All right. Now, in terms of when guardianship is appropriate, it's important to recognize that inability is a basis for guardianship, not disability. So there must be a disability or medical condition that makes guardianship appropriate. Which is only if, because of the disability, the individual lacks capacity to make decisions and there are no less restrictive alternatives available. The person seeking guardianship must prove that due to a disability, the individual is unable to manage personal or financial decisions, and generally that the person petitioning for guardianship must present an opinion from a doctor, or in the case of an individual with a developmental disability, a psychologist is also acceptable. And they will have to show again that because of their disability, they do not have the capacity to make decisions and there aren't other less restrictive alternatives available. Again, this is a significant deprivation of individual liberty. So as a result, it must be a tool of last resort and only pursued as necessary to promote the person's well-being, protect them from neglect, exploitation, or abuse, and to encourage the development of maximum self-reliance and independence. It's also supposed to be tailored to what is actually needed to meet the limitations, and Christina will talk about that a little bit more later. So if the individual needs help making decisions but has needed support, such as a representative payee, a power of attorney, or supported decision maker, they may not need a guardian. Right. They're also just in the case law, it kind of goes a little bit further into this in terms of if someone has the capacity to manage their personal or financial affairs, but they require help from others to meet their daily living needs, and it's a matter of physical needs, that is not a basis for guardianship. As long as the person can direct their needs and indicate to others what help they need, guardianship is not appropriate. So for example, if you have an individual with cerebral palsy who requires extensive physical support but can otherwise direct their care needs or other needs, guardianship would not be appropriate. Right. I'll turn it over to Christina for a bit.
Thank you, Stacy. So I'm going to start out by talking about some different types of guardianships and the terms that are used. I think this will address some of the questions, a few questions that have been posed so far. So to start out with, a temporary guardianship, the court may put this in place at the beginning of a case, most likely, if it is shown right when a petition for guardianship is filed that there is some emergency where a guardianship is needed right away for the immediate welfare and protection of the alleged disabled individual. In most cases, there is a healthcare emergency that is present when a court puts this in place, where it is shown that an individual does not have capacity, and there might be consent needed for a medical procedure or to obtain medical information or something like that. Temporary guardianship expires after 60 days unless the court renews it. And then in total, it can be in place for up to 120 days. You can have either a temporary guardian of the person or a temporary guardian of the estate. So moving on to a guardian of the person. A guardian of the person is over person's medical decisions, personal decisions, and often involves also access to information, healthcare information about the individual. You can have a limited guardian of the person or a plenary guardian of the person, which I will explain in a moment as well. A guardian of the person also may have authority to make decisions over where an individual lives. However, that is only the case if they are specifically ordered by the court that they have that authority. And a guardian does not automatically have the authority to make decisions about where an individual lives, unless they are the Office of State Guardian. That's the only exception to that. And then moving on, another type of guardian is a guardian of the estate. Again, you can have a limited or a plenary guardian of the estate. And if the court appoints a guardian of the estate, they are in charge of financial decisions. Then they also have the ability to sign contracts or engage in lawsuits on behalf of the individual. So, what is the difference between a plenary or a limited guardian? If the court appoints a plenary guardian, that means that the court makes a finding that the individual lacks full capacity to make decisions. And in that case, a guardian, is given all the power and authority to exercise, these legal rights of the warden in this area, either of the person or estate. If the court appoints a guardian of the person and or estate, there's no finding of incapacity. But the court will will state, what are the exact powers and what type of authority or decisions, a guardian has over an individual. For example, court might appoint a limited guardian of the person to help with certain types of medical decisions. It might just grant, a guardian the authority to have access to an individual's healthcare information. But in the case of a limited guardianship, the court has to specifically state in the court order, what exactly the guardian's duties and what their authority is. Next slide, please. So if the court appoints a guardian of the person, what are some of the duties that they have? So first of all, a guardian of the person must, has custody of the ward and any minor children or dependent adult children that the ward has. Again, a ward refers to someone who is under guardianship, who has a guardian. The guardian also has the duty to maximize the ward's independence and self-reliance. This gets at, making sure that, they have access to the community, live in the most, least restrictive environment, are developing skills, addressing, their goals to live, the most independent life that they can. In addition, a guardian of the person must also, make regular reports to the court about the individual. The court will specify, when those reports must be made. Some courts require those to be every year. Some require them to be every 3 years. But it depends on the court. So moving on, how does, when a guardian has a decision to make, how are they supposed to go about making that decision? So under the Illinois Probate Act, it directs a guardian of the person that they first have to consider what the ward's preferences are when they, are faced with making a decision on the ward's behalf. So they first have to try to figure out, what are the ward's preferences, or if they are reasonably ascertainable. And so, then the guardian's decision must follow what the ward's current preferences are. And the only exception to this is if there is a reasonable belief that the ward's preferences would result in substantial harm to their welfare, their person, or their finances. So what does this mean? This means that the guardian has to have a reason for saying no to what the ward's wishes are, or not following their wishes. And really, the guardian has to point to something specific in order to, meet this, this definition of a reasonable belief. So they can't just have a generalized fear that this could harm the individual. It should be something that happened recently and is likely to happen again. So, for example, if a ward wants to be able to lock their bedroom door, wants to be able to have a lock on their bedroom door, but the guardian disagrees with this and says that, they cannot have a lock on their door because they have a history of self-harm. Well, if this is something that happened, many years ago, and, there are no signs that this is something that's going to happen again, then, this is not a reasonable belief. And, the individual should be able to have a lock on their bedroom door. If it's a situation where, the fear still, the fear is reasonable, staff should still, work with the individual towards, trying to meet those goals towards more independence. And, as I just discussed, the guardian has a duty to do that as well. Then in returning back to our, analysis of the decision-making standard, if there is a fear of substantial harm that is reasonable, Then, when the guardian is trying to figure out what to do, the guardian has to take into account what the ward would have done or intended to be if they were competent. And so in trying to figure that out, they should take into account the ward's personal, religious, philosophical, ethical, and moral beliefs, and what they may have previously expressed. So, after that, if the guardian is not able to figure out what the ward's wishes are after making it a reasonable effort, or if the ward's, preferences would have resulted in substantial harm, and they're not able to figure out what the ward would have done if competent, then the guardian of the person should make a decision that is in the ward's best interests. And they do that by weighing these factors. First, they look at the reason for the proposed action, the benefit or the necessity of the action, and the possible risks and other consequences. They also look at alternatives and benefits, and they can also consider the views of the ward's trusted family and friends. So moving on, if an individual has a guardian of the person, what are some of their rights that still remain even though they have a guardian? So we're going to look at some specific issues and situations that an individual might face. So first of all, forced sterilization. An individual has a right to be free from forced sterilization without due process. And under the Probate Act, it sets forth a very specific process that must be followed before a court grants a guardian the authority to consent to sterilize a ward. So first of all, the guardian must file a petition with the court for that consent. In that process, a guardian ad litem will be appointed. That is someone who is appointed by the court to do an investigation and make a recommendation to the court. A ward also has a right to an attorney in this proceeding if they object to the sterilization. In addition, looking at if an individual has a right to marry, and they have a guardian. So under the Probate Act, a guardian of the person must petition the court for permission to consent to marriage. And the court may authorize it if there is clear and convincing evidence that marriage is in the ward's best interest. If the guardian refuses to file that petition and seek permission for the court, the ward, can seek to file a petition to modify the guardianship, so that, to ask the court to find that they can consent, or they can also write a letter to the court to bring this matter to their attention. And we'll talk about that in a few minutes as well. So moving on, talking about other involuntary treatments. Under the Illinois Mental Health Code and Developmental Disability Code, this prohibits a guardian from consenting to the administration of psychotropic medication and electroconvulsive therapy when an individual objects. So if an individual refuses to take this medication or receive this treatment, a guardian cannot consent over their objection. The guardian in that case must petition a court for approval to administer these involuntary procedures. And there is a, statutory requirements under this process. And moving on to talk about residential placement decisions, which we touched on a little bit earlier. So as we talked about, when a court appoints an individual a guardian of the person, the order will state whether the guardian has the power to make residential placement decisions, and whether the guardian can do so without further court order. In some instances, a order might say that, a guardian has the authority to make residential placement decisions, but, must first seek the approval of the court before moving an individual. However, if nothing is stated in the court order about residential placement, then the guardian does not have any power to make an individual's residential placement decisions. And the only exception to this is the Office of State Guardian or the public guardian. They automatically do have the authority. Though even where the court grants the guardian the right to make residential placement decisions, the Probate Act still sets forth a standard for what are requirements for how the guardian must go about making those decisions. And it follows similar to the decision-making standard, which we already just talked about. And so, in the same line, the Probate Act says that the guardian's decisions about where a ward lives must follow the ward's wishes on where they want to live. And the exception to that is if it is reasonably certain, if a ward's decision is reasonably certain to result in substantial harm to the ward or their estate. In addition, if a ward's wishes are not known or are certain to result in harm, then the guardian must make placement decisions which are in the ward's best interest. Also, there are a few other principles. If an individual has a right not to be necessarily separated from friends and family. A guardian also has the duty to monitor an individual's placement to make sure that it is appropriate, and to pursue alternatives as needed. Just because a placement is appropriate at one time doesn't necessarily mean that it's still going to be appropriate, 2 years down the line or 5 years down the line. And this is also guided by what the Probate Act says, the guardian's duty to assist the ward in developing abilities to maximize their self-reliance and independence. So moving on, talking about healthcare records and guardian of the person. Under federal law, HIPAA allows disclosure of confidential information to personal representatives. And this includes guardians, healthcare powers of attorneys, and other lawful surrogate decision makers. A state law, the Illinois Mental Health and Developmental Disabilities Confidentiality Act, allows guardians to also access mental health records of their adult wards. Though this law does not prevent guardians, does not provide that a guardian can prevent a ward from accessing their own records, unless that is specifically contained we would say a guardian cannot prevent a ward from accessing their own records unless that is specifically contained in the court order. So unless a court has removed that right of theirs. Lastly, under the State Mental Health and Developmental Confidentiality Act, indigent wards are to receive a copy of records at no charge, and can obtain legal services to assist them from the Guardianship and Advocacy or EFE in reviewing those records. Okay, moving on to a guardian of the estate. So if a court appoints a guardian of the estate over an individual, a ward loses the right to contract if they are appointed a plenary guardianship, which is a full guardianship, a finding of incapacity. So, in losing the right to sign a contract and enter into a contract, that is a pretty serious loss of rights. However, if a contract is entered into by an innocent third party, someone who did not know that this individual was under a guardianship at the time that they signed the contract with them, that contract is voidable by a guardian. There are some limitations on a guardian of the estate's authority. Those include that they must provide for the comfort and suitable support and education of the ward and any of the ward's dependents. The guardian must manage the estate frugally, care and management of the estate, any real estate and any investments. In addition, this is a very important restriction that a guardian cannot sell, mortgage or lease real estate or personal property without first obtaining permission from the court. And so without first obtaining a court order providing them with that permission. In addition, similar to a guardian of the person, a guardian must report estate income and expenses to the court on a regular basis. So how does a guardian of the estate make decisions on behalf of the ward? So the Probate Act says that a guardian, a court may authorize a guardian to use funds, that are not needed for a ward's current or future maintenance, in following how the ward wants to spend their money. So the Probate Act says that disbursements may be made, as the ward wishes, and as best as they can be, ascertained whether or not tax savings are involved. In addition, it's important to note that a guardian can, give the ward's funds directly to them, and they, can hold their own money. Lastly, a guardian does need court approval before, if they are seeking to be paid for themselves for being an individual's guardian. They really should, they really need to seek court permission to be, paid from the ward's funds, and they should seek court approval for large purchases as well. So, it's important to keep in mind that just because an individual was at one time appointed a guardian, does not mean that, this guardianship is then in place for the rest of their lives. So a ward can go back to court at any time and request that another person become a guardian, or that the guardian's powers be limited, or that the guardian be terminated. And there are 3 ways to do so. So the first way is that the ward or anyone else on their behalf can file a petition with the court and show that they have the capacity to perform the tasks that are necessary for, to care for themselves or manage their estates. And they have to show that they can do so by clear and convincing evidence. So under this first way, the court does not require there to be a report of physician to support this, but it is advisable in order to meet this standard in the Probate Act of clear and convincing evidence. The second way to do so is to for the individual under guardianship or anyone on their behalf to file a petition, which has 3 elements. One is a completed report of physician that it says that the individual no longer needs a guardian. The second is to show that the person no longer wants to be a guardian, no longer wants to have a guardian. And the third way is for the guardian to agree that the person with a disability, doesn't need a guardian and it's in their best interest to terminate or modify the guardianship. So again, with all, in this way, a physician's report is required. But in the first way, it's not required, but, it is advisable to have that support to either, modify the guardianship or, to limit it or to terminate it. So the last way is for the individual or, anyone can actually write a letter or call the court at any time to explain, that they want to become their own guardian. This method can also be used at any time to inform the court of some concern about the individual. If the guardian, is not responding to something that's critical for the individual's care, if the guardian is doing something that is harmful to the individual, this is an important way for the court to be made aware of a situation and know that they need to get involved and do something about it. So it's important to note that the Illinois Probate Act specifically says that this is a method that can be used to notify the court. And after the court receives this letter or a call, a guardian ad litem will likely be appointed to look into the concerns. So a guardian can also be removed for cause, and the Probate Act specifically sets out many different reasons why a guardian can be removed. So an individual can file a petition for removal for cause of a guardian for inappropriately exercising their duties. And the Probate Act discusses some of these include mismanagement or waste of an estate, failing to file an accounting after being ordered to do so, showing that they are incapable or unsuitable for being a guardian, or if they are convicted of a felony or for other good cause. Again, if one of these petitions is filed, the court will require the guardian to file a response to explain why, if they think they should not be removed, why they should not be removed. And why the letters of office should remain undisturbed. And now I'm going to turn it back over to Stacy to talk about provider responsibilities.
Okay, and thanks, Christina. We'll go through the next couple of slides, and then I think we should go through some questions, and then we can get onto the scenarios that we're happy to discuss with you. So in terms of a provider's responsibilities, of course, providers can't simply do what the guardian tells them to do. Providers specifically here in home and community-based services, providing SILA or other related services to people with developmental disabilities, have multiple legal obligations. Those include the federal settings rule that everyone's working on making sure they're in compliance with by March of 23. There's the Illinois Mental Health and Developmental Disability Code. And then there's the Illinois Administrative Code, which also has some specifics about both the Mental Health and Developmental Disabilities Code, as well as SILA provider and other types of community-based service regulations. So the guardian said so is not a reason to restrict an individual's rights. The provider must meet statutory requirements before restricting any kind of rights. That those restrictions must be to whether it's, depending on what the restriction is, to address harm, to help avoid harassment situations, intimidation situations, and that restriction must be documented and reviewed just as the law would require it, regardless if it's something that the guardian wants to stay as the status quo. There's some in the FAQs that were part of the materials that were supplied. There are some summaries of the applicable laws, but some of the main things to think about, like under the Illinois Mental Health and Developmental Disabilities Code, individuals are entitled to reside in the least restrictive environment. They're entitled to a certain level of counseling even without the guardian's consent. They're required to be allowed to be involved in planning for their care. They have a right to privacy, and they have a right to have a means to communicate with others and to visit with others. They have a right to possess property. And these things, though, are not necessarily in competition with guardianship. So as you can see, there's certain things that are required under the home and community-based regulations and the settings rule, for instance, that are completely consistent with the guardianship requirements. Person-centered planning under the settings rule has to reflect the individual's preferences and goals, and the individual with a disability is supposed to directly contribute to the process, while at the same time the guardian is required to follow the ward's decisions as expressed, unless they would result in substantial harm. So these things are really consistent with each other. Likewise, under the settings rule, the individual must be integrated and have the ability to fully access the greater community. They're supposed to have autonomy and independence in making life choices. And they're also supposed to be selecting a setting from various options. Similarly, under guardianship law, the guardian has a responsibility to promote the individual living as fully and independently as possible. They must allow the ward to live where they would like and not be separated from family and friends, absent some fear, not fear, but also real evidence supporting there's a chance of substantial harm. And the guardian has a duty to ongoing monitoring of the placement to make sure it stays appropriate. So again, these are all consistent with the settings rules. The settings rules themselves do not speak of a guardian's choice, but the individual's choice and rights. So it's important that providers are educating guardians on the setting rules and Illinois laws when conflicts come up, and the rights that they confer to individuals with disabilities that are living in waiver settings. Basically, if the individual is going to be receiving these services under these laws, then the provider has a responsibility to make sure that the services are being provided in compliance with the law. And if the guardian insists on a restriction and there isn't a sufficient basis for the restriction, if the provider put it in place, it could put the provider in conflict with the settings rule and Illinois laws, and possibly impact their continued ability to provide services to people. So Obviously, providers do not want to necessarily be in conflict with guardians, but it is important to educate guardians about these requirements that providers really don't have a choice to ignore. Bring the independent service coordinator in if it's necessary to help try to mediate the situation and ensure that the individual's rights are followed. And also with that option that Christina noted earlier, simply writing the court if you aren't able to resolve it about the guardian's activities, so the court can decide whether to take action through possibly appointing a guardian ad litem. And there's different scenarios set forth in the frequently asked questions to kind of help work through these processes to try to resolve these type of disputes. Right, maybe before again we get to the scenarios, let's see what we have for the Q&A. Okay. So in terms of the first question, it has to do with a day program allowing participants to go on outings without a permission slip. And isn't the agency still supposed to give courtesy to the guardian in informing them of outings? I think that has a few different parts of it. I think at first it'd be important that the guardian and a provider have an understanding at the beginning of the programming as to what level of notification the guardian would like to have. The guardian should not be interfering with outings without, again, some reason to believe that allowing the person to go on the outing would result in substantial harm. I don't know, Christina, do you have anything to say on that one? Anything more?
No, I think I agree with your answer there.
Okay, you're welcome to take the next one if you want.
Sure. Yeah. The next question asks, if a person has a guardian and the guardian doesn't want the responsibility anymore, what are the steps for the guardian to resign? So in this case, the guardian has the responsibility to notify the court that they no longer want to be the guardian. And, either if a successor guardian needs to be appointed, or if they don't think, the guardian, if the individual needs a guardian anymore. But, just by the guardian can't just tell the provider that they resign and that no longer the guardian. They have to inform the court, and the court has to, formally remove them and, appoint a successor.
All right, and then for the next question was, does guardianship carry across the state of Illinois, or is it per county? So if an individual lives in DuPage County and a guardian was obtained in that county, what happens if the individual moves to a different county? Is the guardianship still valid? Do they need to go back to court? So, so if an individual moves and they are planning on staying in their new location, they should, whether it's the guardian or someone else, if the guardian is not actively involved, should file something with the court in the original county to let the court know that the guardian, or to ask that the guardianship be transferred to the new county where the individual is living. It makes it much more efficient for the court to monitor the guardianship if it's in the correct county, and if there's anything that is needed from the court, having it in the county where the individual lives is the most appropriate situation. Christina, you want to take the next one or add on?
Sure. Yeah. The next question is, how many supporters can be listed in supportive decision-making agreements? My understanding is that only one supporter can be listed in each supportive decision-making agreement, but that an individual can have multiple supportive decision-making agreements.
And just the only thing to add on to that is someone might choose one person to help them make decisions about how to spend their money, another person on health decisions, another person on work decisions. So really, It's just by topic, the individual, and an individual can choose to have more than one supported decision maker for one particular topic. So it's supposed to be really flexible and to reflect what the person wants. Okay, so the next question, what are the ways to obtain the letter of guardianship if the guardian no longer has a copy of it? So that should be something that the guardian can obtain as well as others, just through a request to the court to request a copy. The main thing you really need to know is the county of where the guardianship is, as well as, of course, the individual's name and date of birth, and the case number is helpful, but you really need to know the county where it is because there is no statewide database of guardianships. So you don't know which county they might be in.
The next question is, can you talk about the difference between the Office of State Guardian and the Office of Public Guardian? So the Office of State Guardian is the guardian of last resort for individuals in Illinois. So they are appointed when there are no other family members or friends or no one else that can serve as an individual's guardian. And they also serve when individuals don't have any funds to pay for the professional services of a guardian. So I believe when individuals do have funds, then of over 20,000, then the Office of Public Guardian will be appointed, and they are there's an Office of Public Guardian for every county. So in Cook County, there are there's a whole office, and I think per county there might be in other counties there might be one individual who is appointed. Well, there is one individual, in Cook County as well. But there's a whole office around that. And in some counties it is, just one, just one individual. But the difference between the Office of State Guardian and Office of Public Guardian is determined by how much funds an individual has.
Okay, I will take the next one. It says, why are each county courts different? Some require reports, others don't. Oh, I'm sorry, I skipped the one. Why is it the case that an individual can revoke power of attorney over health and not a power of attorney over property based on capacity? I don't know specifically, but one thing I can think of, one reason why maybe someone with the power of attorney over health can revoke it even when they don't have capacity is because there are other means to obtain decision-making authority if someone revokes their power of attorney for healthcare and they need a decision maker, such as, if it's for involuntary treatment, which of course a guardian doesn't even have the authority to do, there is a process through the Mental Health and Developmental Disabilities Code to obtain that involuntary treatment. Of course, guardianship would be available in either situation. But because I guess these healthcare decisions are so personal, they're giving people authority to revoke a power of attorney if they do not agree with their power of attorney any longer. That's my best thoughts on it. I don't know, Christina, if you have any others.
No, that makes sense. Okay, the next question is, why are each county courts different? Some require reports, others don't. Some grant guardianship plenary when limited might be better. The way our state court system works, each county, has a different court administration. And so, all the courts are required to follow the Illinois probate laws. They each have to follow these laws that, we discussed here today, but the kind of court administration and the way they go about handling their cases in some ways is different. Some is based on, a court's capacity. Some have a whole division that deal with just adult guardianships, and some, a judge hears all different types of cases, not only guardianship cases, but criminal cases and family law cases. So, it's just the way that they're handled.
And just a little bit more on that too. It's not limited to Illinois. I think it's really a countrywide problem, but most guardianship laws are written that a limited guardianship is preferred over plenary. If a limited guardianship does the trick, then it should not be the broad plenary order. And so part of, I believe, in terms of making sure someone has a limited guardianship, when that's really the better option, is making sure that people are advocating for that to the court and educating the court about the individual's abilities and their needs. Because it's just, unfortunately, maybe because they have a lot of other practice areas that they work in, like Christina mentioned, they don't maybe focus in on that really preference for limited guardianship, because it's only supposed to be ordered to the extent necessitated by the individual's needs and all the other factors there. So that's one problem. And then I know that like Cook County, for instance, has more specific rules about like the annual personal report and the annual financial report, and the other counties throughout the state, have different requirements. There is a requirement in the Probate Act that a financial report, if there's a guardian of the state, has to be filed every 3 years. That's a baseline for counties other than Cook County, but otherwise it's kind of as the court's order, or if there's local rules for the particular county. All right. The next question. I work for a SILA provider, and we have guardians constantly asking about food and diets and want us to restrict certain foods. We do not restrict food ever, but what would be a good response to the guardians? I think if it comes down to a fact that it's not really a medical condition, like a medically ordered diet, that the answer is that, you have obligations under the law to respect the individual's choices, and that, the guardian's choosing for them to receive home and community-based services, and that as a result, you as a provider have to meet your obligations as a provider. Christina, if you have other thoughts on that.
Yeah, no, that makes sense. And we have a scenario that we're gonna talk about in a little bit. We'll go through that a little bit more as well. The next question is, can a guardian make someone use birth control, have an abortion, or put a child up for adoption? So, this involves the decision-making standard that we talked about if an individual has a guardian of the person. So, I would say that, if a guardian, wants an individual to use birth control, have an abortion, or put a child up for adoption, and this runs counter to the individual's expressed wishes, and for example, if the guardian can't point to a specific harm that, for instance, an individual would have if they, or no medical condition, for instance, if they, would have for, going through with a pregnancy, and that's something that they would want if the guardian and the individual's wishes conflict, then that's an issue that should be brought before the guardianship court to address that conflict.
Yeah,
Stacey, do you have any more thoughts there?
I think that these are some pretty serious restrictions going on there, especially obviously birth control is important, but the abortion or put a child up for adoption, that's really where someone's the ward, if they had the ability to say they don't want these things, or they want to keep the child, then really they should have their own attorney. So Equip for Equality is a good reach out on something like that. Obviously notifying the court if the individual isn't able to find an attorney, so the court can appoint one to them, because that's a pretty substantial issue right there. Okay, so the next one, when the guardian disagrees with the ward on a topic like a lock on the bedroom door or dietary restrictions such as dairy or gluten-free, assuming that the agency and doctors agree with the ward, what action can an agency take or ward take to overcome the guardian's preference? What costs would be incurred by the agency ward? So again, this is one where I really think, based on the standard for guardian decision-making, if the doctors especially are agreeing that this is not necessary, or there really isn't any kind of substantial harm that's being pointed out with regard to the lock on the door, that bring the independent service coordinator in to try to meet with the guardian and educate the guardian. If that doesn't work, can reach out to the court by letter. The one thing nice about that is that it's really, of course, an agency should work with their own attorney, but if you're reaching out to the court by letter about concerns about the guardian's decision-making, you're not necessarily entering your appearance in the case or anything like that. You're just educating the court about some situations that are going on with the guardianship. Really good idea, as we note in the FAQs, to actually cite the statute about the ability to communicate concerns to the court about the guardianship, because sometimes courts get confused and think it's improper ex parte communication, basically communication to the court without having an appearance in the case or informing the other parties. But really, that's not how the guardianship statute is set up. So it's a good idea to cite that statute. In terms of cost to the ward, if the judge, for instance, appointed a guardian ad litem, there can be some charges to the ward or to the guardian. But at the same time, if the individual is without resources, that should definitely be something to be brought to the court's attention, because lack of resources doesn't mean they don't get to be heard by the court.
So the next two questions, maybe I can kind of combine answer together. They involve like a guardian's refusal to consent to psychotropic medication, or then at some point trying to reduce or remove that consent for medication when an individual wants to take that medication. I think that going back to the decision-making standard for a guardian of the person, if this medication is still recommended by an individual's doctor or psychiatrist, it's going to be hard for the guardian to point to, unless, I guess it's going to be hard to point to a specific, a substantial harm that, would support their decision, unless an individual is reporting, some severe, could be some severe side effects from the medication that, a doctor isn't taking into account, for instance, or, that a provider is seeing if an individual, can't communicate those. But again, if there are concerns that, a guardian's decision to revoke or, refuse to consent to medications, which a doctor is recommending, and an individual, wants to take, or wants to take, then this is an issue that also should be, brought to the court's attention, or, addition contacting us.
Yeah.
Stacey, if you have any other.
Yeah, the
thoughts
only
there.
other thing I would say, if it's gotten to the point where it's actual neglect by the guardian, and I know that's a far step to say that the guardian's neglecting the individual, but if there's evidence of that, then it should be reported to Adult Protective Services as well, because they can also write to the court or about any substantiated findings that they have involving a guardian. Right. And then the next question, can a letter of concern be submitted anonymously or must it be officially signed as a means to review the guardianship? So I would say it's more effective for it to be actually signed with someone for the court to contact and the guardian ad litem to contact. But if that's not possible, then, anonymous is better than no report to the court if there's concern going on with the individual. All right.
Okay, the next question is, there might be an interest in allowing co-guardians. Also, when can guardians be out of state? Can guardians of a state be out of state? Guardian of the person? Yeah, sometimes family members, they'd like to be appointed to family members, especially in cases when one family member might be getting older, and, might at some point want to pass along the responsibility of guardian to another family member. So co-guardians can be allowed. I think the court can appoint co-guardians. I think sometimes, they are disfavored by courts because there can be issues when the co-guardians themselves disagree on how to make decisions on behalf of the ward, but they are allowed. In addition, guardians can be, the court can appoint a guardian of the person or a guardian of the estate to be out of state, so long as they find that the guardian can still fully perform their duties out of state.
Right. Next question. Can a person with ID in a state institution be determined to have capacity and make decisions about medications, living arrangements, etc., if they have a state guardian? So really, it sounds like this situation, if the individual does have capacity to make certain decisions, there's an option to go back to court, not only to revoke the guardianship itself, if that were appropriate, but also to modify the guardianship. So that could be modified to a limited guardianship that gives the individuals certain decision-making capacity under the letters of office, and then reserving what they need to have a substitute decision-making maker for as what remains with the guardian. But as long as the guardianship order is written as is, it stands. Now, a guardian themselves can say, I consent to them making decisions about these things as part of their responsibility to help promote someone's independence and growth.
The next question, are there specific ways to challenge specific decisions being made by a guardian on behalf of their ward when it seems that their decision is not in line with the ward's choice or preference? So, we would recommend, first trying to, educate the guardian about, informing them, about their obligations, under the Probate Act. If it seems like the decision that they're making does not align with the decision-making, standards that we discussed here today. In addition, if it involves, going against, the settings rules again, with regard to a specific area, if the guardian is not, open to that, still after, trying to educate them on those issues, involving the ISC agencies as well in those discussions, can be helpful. And if that is, still not, the guardian is still insistent, you can contact Equip for Equality, you can contact us, or you can contact, you can also, writing to the court, as we've discussed as well.
All right, this next question kind of feeds into what Christina was just saying about attorneys, but can you give us a pro bono attorney for individuals with disabilities? Usually individuals are unable to pay for services. So Equip for Equality does represent people with disabilities in guardianship matters. The one important thing is that for the most part, the individual has to be able to express that they want our help, in whatever means that they express that, as well as be willing to go to court. I should step back from that. Sometimes we can get involved and try to help resolve it for the individual, but sometimes those individuals are not interested in going into court. If they do need to go to court for this particular issue, it's important that they be willing to go to court and challenge their guardian if it becomes necessary, because when we go to court, we're representing that individual, and we have to be able to express to the court that we are representing what they want. And then secondly, Equip for Equality also provides services involving representative payees, like I mentioned earlier. So even if the individual is not able to express themselves and related to the concerns about a representative payee, if there is a concern about a representative payee misusing the individual's money, it's good to reach out to Equip for Equality on that as well, because we can ask Social Security if we can conduct a review of the representative payee. So that's a kind of a special project that's a little bit different. Otherwise, some state legal aid providers throughout the state might provide pro bono attorney for guardianship issues, but they don't really have a lot of programs that specialize in that, but it doesn't hurt to check.
The next question, what safeguards does a provider have, I think, in relation to a person with a history of self-abuse and wants to lock their doors? So if, if an individual, does, have a history of self-abuse, and the, a guardian is also involved, and, for instance, they don't want the door locked, or, they don't have a guardian, but, there's some concern that, that any delay in sort of being able to, I think, and being able to have access to the individual, could be, some sort of serious threat. I think then, the provider would have reason not to, not to allow a block on an individual's door. Is that your understanding?
Yeah, I think that
Stacey?
comes down to going, through the restriction of rights, Human Rights Committee process. And so the idea is that if it is necessary to prevent harm, to restrict that right, then you need to follow that process. You need to ensure that it's reviewed periodically to see if the situation has changed. So it's not just a simple no. All right, and then the next, it says, how will providers, in this case, community service, know what type of guardianship is held, whether it's plenary or limited? And this really gets down to having a copy of that court order and the letters of office. Really, the letters of office should summarize what the court order said in terms of what the guardian's authority is. So if they're limited, if the letters of office should say that. If they're plenary, the letters of office should say that. And it's really important if you're taking direction from somebody that you have a copy of that limited or of that letter of office, because it's really going to allow you to know what authority you can take from the guardian.
The next question, what if personal planning process is not focused on individual wants and desires, but more so on the guardian's desires? I I have sat in on several meetings where the individual award is not even addressed. All questions are posed to the guardian. So yeah, that, you know, that does not, that does not that seems to run, counter to what, the personal planning and, setting rules, lay out that, these meetings should really be, focused on, on what the individual wants, and, they should be, the focus of these meetings, and they should be the ones who should be, directed during these meetings, and setting their personal plan. I think trying to, make that clear at the outset of the meetings, and also if a guardian, is very, disruptive during a meeting, and, trying to run the meeting, that needs to be addressed as well.
All right. The next question is there a mass mailing or some sort of communication that is being sent to the guardian on the rule changes? So I personally am not aware of that, although we were talking with CQL in relation to preparing this training, that it might be helpful to kind of put together a one-pager that would be put in terms that might be accessible to multiple reading levels, to kind of let people know not only about the settings rule, but also existing Illinois law that has been in place and requires providers to respect certain wishes. So it sounds like that might be a useful thing, and then something we're thinking about working on after we finish this presentation. I think you can move to the next one.
Yeah.
Oh, there's the guardian. There we go.
Okay. I'm a plenary guardian for my son. When I get really old, can I direct the court to name my daughter as guardian? Can I ask the court not to make her guardian, even if she asks? So in naming a successor guardian, the court has an obligation to listen to the preferences of the ward, and who they want to be named as guardian. If you come to a point where if a guardian comes to a point where they want to be, no longer can or want to be, the guardian, they can file, when they notify the court, they can notify the court that, I recommend, this person be named a successor guardian, or someone else, not be named guardian for these reasons. There is also a process under the Probate Act to appoint what's called a standby guardian, where successor guardians can be designated as well.
And the standby would be kind of like something that you might explore, so that way you have some involvement in who's selected, and also things sometimes happen when you don't have a chance to play a role in having a successor appointed. So it would be something you can do when you are able, instead of leaving it to chance later. Right. And then it said, will this be a new process for parents who are guardians? Is it reviewed frequently? I'm not sure in terms of the, exactly what this is getting to, but to the extent it has to do with like this process for involving individuals with decision making, they really should have been all along. So if that comes up, it's really not new in that way. But some people are maybe not so familiar with their obligations, including their obligations to promote someone being as independent as possible, because they really aren't the individual's boss. They're there to help them make decisions and support them to ensure they're as independent as possible. Okay.
The next question, I may have missed this, but are provider staff allowed to be supported decision makers, or is that a conflict of interest? Currently, no, they're not. Under the Illinois Supported Decision Making Act, providers are not allowed to be supporters.
Next question, is COVID-19 a reasonable reason for a guardian to want an individual to not attend day training or other community outings, no matter the changes over time with CDC recommendations? I mean, part of the reasonableness probably has to do with the individual's condition, and hopefully the guardian, if the individual is able to be vaccinated, allowed that to happen as well. So there can be different risk factors depending on, again, someone's vaccination status, on their health condition. It certainly could be seen as a restriction on their ability to become more independent and grow and become more self-sufficient. So that is a problem if it's not a reasonable decision and based on actual risk of substantial harm. So that's where, if they are just refusing and there really isn't a good basis, providing education, working with the independent service coordinator, and then possibly reaching out to the court about the nature of the decisions that are being made.
I have a client whose guardian is very elderly, about 95, 96. She understands that she can no longer be his guardian and there is no other family member to take over guardianship. Would that be, would a state guardian be the only option, or is there any other options? Yes, if the individual does not have any other family member, has funds under $20,000, I think, then the Office of State Guardian would be the guardian of last resort.
For the supporter, do they go through the court, or is this just done with the individual and home? Yeah, so this is, there's not court involvement here that I'm aware of. Christina, you can correct me if I'm wrong, but there's no court involvement. This is a law that just helps it be more known to whether it's a business or a doctor's office or something, that there is this valid supported decision-making process for people with developmental disabilities. And the forms, like I mentioned, through the Illinois Guardianship and Advocacy Commission site, kind of help people put that together so that they have a document to share if necessary.
What if a guardian says that an individual can't go on an outing and doesn't pay for an outing because the individual has diabetes and doesn't want the individual to have access to unhealthy food? Also, the guardian says that the individual can't go on an outing because the individual did not complete chores at home. Both, I think in both of these instances, this would be an improper restriction, that the guardian is trying to put in place just because the individual is going on an outing. And in the first case with diabetes, doesn't necessarily, mean that they're going to have, access to food necessarily, that would, put their health at risk. And the last thing is, sounds improper to me. The individual is, they're using community access to community time, as taking that away as a form of punishment. And so I think, which is improper. So I think in both of these, issues, the guardian's actions would be improper. Restriction of rights would, I think we'd have to, speak with the guardian and, try to explain to them why their decision is inappropriate.
Right. Right. Next, the scenarios, we have guardians that continue to restrict. Oh wait, there we go. We have a situation in which a family friend will visit the individual, but the family friend is always talking bad about the guardian when visiting. The family friend and guardian do not get along. The guardian has put time limits on the visits along with wanting them supervised due to this reason. The individual has no issue with staff supervising the visits. Is this allowed? So here we are with the individual who is okay with the staff supervision. So if they're okay with it, then that would be allowed. If the individual wasn't okay with it, then I think you would need to look into whether the visits were causing the individual harm. You know, there certainly could be harm if it's causing discord with the individual, not necessarily reflecting badly on the guardian, but causing the individual significant stress. Then you might have some the least restrictive options available that you would put in place as long as you met the other requirements of the restrictions process. But if the individual is okay with it, I don't see it being a problem.
Next question, we have guardians that continue to restrict individuals from participating in photos, videos for the agency. There's no valid reason and the individuals want to participate and have the pictures on Facebook. Any suggestions? You know, in this case, if it's, you know, it's something that the individual wants to participate in, you know, again, I think that, you know, the individual should be, you know, allowed to participate. You know, if you can demonstrate, especially that, you know, the individual understands, you know, what, you know, the purpose of the photos are, you know, the videos are, and, you know, kind of wants to be, you know, wants to be involved and being a face of the agency. I think, you know, explaining, again, explaining to the individual, explaining to the guardian that, you know, there's no there's no risk of harm here, and it's the individual's choice to participate.
Right. Next one is guardian is wanting paychecks that individual has earned from work at the CDS placed into account so they can use it as reinforcement of behaviors. Agency is rep payee and do not agree with this nor want to do this. Guardian continues to state they are the guardians and this is what they want. What can we tell the guardians? So there's a couple things going on here. I guess the first question I would have is whether the guardian is guardian of the estate or guardian of the person. If they aren't guardian of the estate, they should not be directing where this individual's work funds go. The individual should be part of that decision and be able to maintain their own account. If the agency is representative payee, they also don't really have any authority of what the individual is earning at work. I know that the agency has to report information to Social Security if they're the representative payee, but they also don't have authority over it. Ultimately, we're still coming down to if it's a guardian of the estate, that they have the obligation to make sure that the individual has access to their funds to spend as they will, unless there's some kind of harm that's going to result from that. Their money should not be necessarily used as punishment for certain issues, kind of like Christina was saying before about outings. You know, they do have a right to access their money and to buy property under a state law, under federal law, and even under the Probate Act for the guardianship, where if it's a guardian of the state, where they really have to look at what the individual wants and agree with and to let them do so unless there's like really some harm at issue.
Stacy, I know we're past 1:30. I don't know if we.
I can keep going till 1:45, but then I have to stop. So I think the questions probably cover a lot of our scenarios. So I can keep on going, but if you need to go.
Great. No, I can keep going too. I just wanted to check. So the next question.
Anne, are you still good or are you exhausted? if you need to stop, we will have the transcript. So,
I think it'll be fine. Yeah,
okay,
thank you for
thank you.
asking. Yeah.
Okay, great. We'll take a few more questions here. So the next question, if the guardian of a ward is incarcerated and inaccessible, yes, then, if a guardian is incarcerated, unable to communicate, unable to, fulfill their duties as guardian, then the guardianship court needs to be notified of this. So a successor guardian can be appointed if necessary.
Next question, does guardianship prohibit an individual from having a driver's license? So I don't know all of the ins and outs in this, but I do know that if you have a plenary guardian, there are some rules in the Secretary of State's division on driver's licenses that do interfere with someone's ability to get a driver's license. I believe someone under guardianship can get an order from the probate court. If the court agrees that it's permissible to obtain a driver's license. And also if someone has a limited guardianship, that's not the same because it's not legal incapacity under the law. So that's one reason why maybe someone would seek out a limited guardianship if they need help on some things and it requires guardianship, but they can do other things.
Hi, I want to ask who educates guardians on setting laws? Well, I think this is, part of the purpose of, today's presentation is giving providers, the tools to, address these issues and in turn educate, the guardians on these laws and their implementation.
All right. And the next question, if an individual in a day program would like education in recognizing sexual abuse and exploitation, but the guardian does not want the individual to receive this education, how should the provider proceed? So again, going back to whether the individual receiving this education would result in substantial harm, that seems fairly unlikely, as this is an individual trying to take action to protect themselves. It would seem like that would not be a reasonable decision on the guardian's part. So I think between educating the guardian about the provider's requirements, again, if the guardian wants the individual to receive services through the home and community-based waivers, then they have to respect that the provider has to follow the rules, as well as the Illinois law on that. And if there's problems with that, again, involving the independent service coordinator or eventually writing the court, because it does not sound like this is a reasonable decision.
The next is an update. Thank you, with a correction from Barry Lowy with the Office of State Guardian. Informing us that the public guardian floor for taking guardianships is $25,000 and OSG has no restrictions, so it can handle larger cases when there is no public guardian willing to act. Thank you very much. The next question is, what if a doctor has ordered a specific diet, such as a diabetic? Does the individual still have the right to choose what they want to eat? So, so this is a tough one. Yeah. So, I guess if there are particular foods that a doctor has specifically ordered, someone not to eat, or have access to, because there is like a very serious risk to some medical condition, then, that could be a basis for, restricting certain foods. but I think so, but this, yeah, Stacy, do you have any other
Yeah, I think it's
thoughts here?
the provider obviously is looking at it from a perspective of, following doctor's orders. If there is a basis for the restriction of rights, then you need to go through the restriction of rights process. If an individual has been deemed not to have capacity to make these kind of decisions, if that's what's contained in the letters of office, there's, that authority is there to restrict it if it's going to result reasonably thought it would result in substantial harm. So I think it's just a matter of trying to make sure it's as least restrictive as possible and that it's reviewed timely. Okay, what kind of authority does durable power of attorney carry? What are the limits? So the document itself sets forth what the powers of the durable power of attorney. So that's going to be, I think when you're speaking of a durable power of attorney, it's property. The limits on it are really based on the fact that the individual is a fiduciary. So if they're making decisions on behalf of someone else, they have obligations to make sure that they are behaving wisely and not stealing. So those some of the limits. So they're supposed to make good investments. They are supposed to help the person manage the money in a way that ensures that they have access to their funds over the course of time that they'll need them to the extent possible. So those are some of the basics of the power of attorney for property. I think we can kind of skip the next.
Yeah. The next question, the guardian wants to put parental controls on an individual's iPad. They feel there are sites that they could stumble on, such as pornographic material on their iPad that would be harmful. An individual bought the iPad. Is this okay? I would say that, I don't know, this is kind of a tough one. I would say, an individual does have, a right to, use their iPad, if it sort of if these restrictions kind of get in the way of using the iPad, that's not okay. I would say that guardian doesn't have the right to limit their access to information unless they can point to, as we discussed, like a specific harm.
Yeah, and one harm I could see, not just generally pornographic material, but if there's a concern that the person would mistakenly access illegal pornographic material, there might be some reason to put those limits on it. The individual wouldn't have the ability to maybe perceive that. That's something, but it's definitely kind of similar to some of the other analysis that we've had. Next one, if a guardian is incapacitated who has decision-making rights, that's definitely one where you're going to need to alert the court to the individual's incapacity, the guardian's incapacity, to make sure that the court addresses that timely.
Next question, what if a guardian is very insistent on only allowing their individual to leave the home if guardian can come and inspect an individual's appearance or get her ready herself, or that the individual have no community access or leaving the home without her permission? Yes, this seems overly restricted and overstepping the guardian's authority. An individual has a right to a right to wear what they want to wear, unless doing it would cause them harm. Like, for instance, if they're don't want to wear enough clothes in the winter that where they could in that way. But a guardian tying them leaving the home to them setting eyes on them and having yeah, putting specific approval on these things is inappropriate. Yeah, I'm guessing probably they're putting other restrictions in place that are inappropriate and should be taken before the court.
All right, next question, can you distinguish between medical orders for diets versus recommended by physician? What does the residential provider have to follow versus letting an individual make a decision that is not best choice? So I think, it gets complicated on this dietary stuff. People without a legal disability can eat in violation of medical orders and in violation of recommended diets. All of us have ways that we can improve in that way. So I think it's really important to educate both the individual and the guardian and try to find strategies to help someone with healthy decision making with food choices, but also recognizing that just because someone has a disability doesn't mean that they can't make food choices that might not be considered healthy.
Next question, has Equip for Equality done specific work with ISC agencies across the state? That could be helpful. Partnership in terms of advancing self-advocacy efforts. Yes, we we've received a number of case referrals from ISC agencies, and we definitely work collaboratively on a number of issues to, from addressing issues with restrictive guardians to addressing issues with provider agencies and services as well.
There's always room for more collaboration.
Yes.
Sometimes we presented, and I think vice versa, but and are always happy to join. I think there's like weekly or bi-weekly ISC meetings, and always happy to present on stuff that we do at those as well. All right. Have guardians, I don't know that this one I can answer about whether they've received letters from DDD about the HCBS settings rule. I have not heard of it, but I'm not in the know on as to whether that's been sent. And I do think there is room for guardians to be informed about these kind of topics, about what providers are required to follow, as well as their own obligations under decision-making standards.
What if a guardian refuses to sign any consents? So a guardian refuses to sign consents, and those consents are necessary for an individual to engage in some activity or, take medication or, whatnot. And that's something that the individual wants to participate in, as we've talked about. And there's no, the guardian can't point to any risk of harm, then that issue needs to be, should involve the ISC, should, contact the court, or, can contact us as well to address.
All right. Next is just a statement that Teresa Park shared. Thank you. It says there's a guardian training module on the GAC website, now a requirement in Illinois for newly appointed guardians unless the court waives. That does, of course, present on a guardian's obligations under the Probate Act, which again are fairly consistent with Illinois law as well as the settings rule. The next question says, we are representative payee, but they do not want them to spend any money. So again, if the representative payee has control over the money, and obviously the guardian has some involvement in helping the individual make sure they save for important things they need, but if it's just some arbitrary, I don't want them to spend money, that would not be a valid decision. And the representative payee has control over the money for the person's best interest and can give them access to it.
The next question, I have guardians afraid to allow their wards to try things because if they get in trouble or hurt, they think they will be liable. I hear similar things from agencies. If an individual makes choices that get them hurt and in trouble, who will be liable if the person is under SILA care? Yeah, I think this is kind of a hard question to answer sort of hypothetically without a kind of specific situation, but just generally, the way we all sort of learn how to make better decisions is by trying things out and making mistakes. And so, I think in general, like we talked about, a guardian has a duty to help a person to, live most independently and, build their skills and, allowing them to make mistakes, is one way to go about that.
All right, I have a guardian who decides where their ward can work in the community. This is upsetting to the individual suggestions. So again, I think this is getting back to educating the guardian about the individual's rights and the limits on what the provider can and can't do under the law. And it really seems that unless there's, again, some identified substantial harm in making the decision that they can only work in a particular place, this is something, if you can't get it resolved with the guardian or the ISC involvement, that inform the court about this, because this is not a proper exercise of authority.
And the last question, what if a guardian restricts access to a cell phone or tablet because over 5 years ago, the individual inappropriately, I'm thinking, contact someone on the internet? Again, like, I think that, that situation was five years ago. I think it's worth revisiting again, especially if, the individual shows that, they understand that, the situation that happened 5 years ago, they made a mistake, providing them with some more education around the internet, maybe, and finding out what they want to use it for, and things like that.
All right.
I think we have set a new record at CQL. You guys answered 88 questions and maxed out registration. So we want to thank you for sharing this information. I think people found it helpful. And again, we did record the webinar. And so we will be sending it out in about a week, a link where you can access it. And we encourage you to share it with others, because there was a lot of discussion about how people are being educated on guardianship and the settings rule. And so thank you for attending today. Thank you to our presenters, and thank you, Anne.
Yes, thank you very much, everyone. And thank you, Anne, for sticking with us.
Thank you.
Bye-bye.